All right, thank you so much. We've come to the major hub of today's presentation, talking about today's issue and the discussion segment. I did tell you that we're going to be looking at the court yesterday, the Supreme Court yesterday, making a ruling and striking out the petition as filed by the People's Democratic Party and Alhaji Atiku Abubakar, the presidential candidate of the PDP at the 2019 presidential election. Talking about the INEC server issue and all that. And it was only yesterday that the Supreme Court had to strike out an appeal filed by the People's Democratic Party and also to its presidential candidate Alhaji Atiku Abubakar. A five-man panel led by Justice Datito Mohammed said the appeal was statute bad. And of course, the appeal was filed by PDP and Atiku to challenge the ruling of the presidential election petition court, which held that they failed to file a response to an application by the All Progressives Congress, and also the APC application had prayed for, among others, the dismissal of the appellant's petition at the tribunal. This came barely 24 hours to the closing arguments of parties to the petition scheduled to come up today. And just like what we said, this whole thing talks about the petition that was put together by PDP and Atiku, trying to question the result that the PDP believes they got from the INEC server about the 2019 presidential election. Well, discussing all of this today, we are so privileged to have Barrister Matthias Obayiwana. So welcome to this program this morning on ITV.
Thank you very much.
And also we have a political discussant, a public affairs analyst, pharmacist Uyi Oreaki. So welcome to this program this morning on ITV.
Thank you.
Also joining us with us is Barrister Andrew Emata. He's a constitutional lawyer by profession. So you're welcome to this program this morning on ITV.
Thank you for having me.
All right. Now, looking at the topic today, also looking at the position of the Supreme Court concerning the server issue results, the PDP and Atiku Abubakar. Now, does this necessarily bring a finality to the petition as filed by PDP and Atiku Abubakar concerning the 2019 presidential election? I'll start with Matthias Obayiwana.
Well, the Supreme Court has spoken on this issue. It does not bring the petition of Atiku to finality. It's only an aspect of the grounds of that petition that it will affect. It will affect it in the sense that the INEC server is supposed to be in the custody of INEC, which is the public institution. And by reason of that fact, under the Section 24 of the Evidence Act, whatever materials that you want to, anybody want to make use of from any document that is in possession of a public officer ought to be certified, and then beyond being certified, those in charge of the management of the server must also authenticate it, that it was brought in the normal course of business and all of that. And machine, the machine from which, the computer from which that document was presented was functioning properly and all of that. These were the hurdles that Atiku tried to skate through by asking the tribunal to allow them access to INEC server, so that INEC will now be compelled to authenticate that result, whatever it is that has come from the server. So they tried to, scale that hurdle, and then the APC's lawyers or Buhari's lawyers were smart enough, to have denied that, there's no server does not exist. Because if they have admitted that a server does exist, then the tribunal will have no option than to compel them, to grant access to PDP to access the server. In which case, you have to authenticate the result from the server. It is not as if Atiku does not have the result from the server. They do. That is why Professor Keyamu at a point petition to EFCC to against Atiku and his crew for hacking the server of INEC. So if the server does not exist, why would you be petitioning that a server have been hacked? Can you hack what does not exist? Mike Igini, former SOG president Uniben, who is a recent electoral commissioner for all the states in for INEC, also come up to explain that yes, there's a server, and they will ensure that the results are transmitted to the server. There's a budget that was made, for before the National Assembly to allow them to pay money for them to create a server.
That's by INEC.
By INEC. We have also seen, witnesses in the election petition who has also come to say, look, we are ad hoc staff for INEC and we transmitted the result to the server. So in all of these, they brought application to tribunal to say, look, allow us access to this server, and tribunal in their wisdom say, look, we will not, because this man said, I do not have a server. So in the face of this overwhelming facts and evidence that a server does exist, I think it would be proper for the tribunal to have granted the access. It was denied, and then they appealed to the Supreme Court on this ground. You have denied our right to fair hearing by refusing us access to the server, which we are able to put evidence before you that it does exist. And the Supreme Court said, look, we cannot question the discretion of the tribunal. The tribunal has ruled on this matter and have not seen overwhelming evidence before me to overturn that decision. For that reason, that aspect of the appeal regarding access to the server, was dismissed by the Supreme Court.
Okay, now according to
that being said, to answer the question that you put forward, does not put pay to the case of the article before the tribunal, because there's already evidence before the tribunal. The only concern I have is that they have at the final address stage, or what they call it, considering this position put forward, Section 24 of the Evidence Act would have been seen to have been fulfilled, in the sense that the man who has possession of this document has not authenticated that it came from their custody. So then the issue will now come whether the document presented by INEC, by article, is from proper custody, and they are satisfied. I mean, they are legally admissible piece of evidence. So again, one way or the other, that may rub off on that particular angle of their petition. Of course, there are other grounds as to qualification, proper certification, of Buhari and the rest of it. So those are issues, that I think the petition is still kicking, and we pray that we want to look at it more carefully, and do justice to the case. Yeah, because as far as the petition is concerned, the rule is that in the case of Abubakar and Yar'Adua, the same Supreme Court has ruled that election petition is sui generis, and they should be liberal enough. The tribunal should be liberal enough to allow parties room to present their case before the court, because it goes beyond the parties themselves and extend to the electorate who are waiting to see the outcome of the result of the election, because we all participated. So it's a national issue that everybody is interested in, not just Atiku or PDP or Buhari and APC. The entire Nigerians, we are interested, we are following up, we want to see how it turns out, so that they won't become another issue of technicalities being enthroned over substantial justice.
But I think it's still that, on that note of that technicalities now, that the Supreme Court may have strike out the petition, because according to what we have here, according to the Chief Judge, he said that the appeal is status bad. I want you to throw more light on that. Yeah,
when they say the appeal is status bad, although I have not gotten the fuller reasoning
judgment
of the Supreme Court on that ground, that the appeal is status bad. If the appeal is status bad, what that simply means in law is that the time frame within which we are presented
as elapsed.
The appeal has elapsed. Yeah. You usually present it within that particular period of time. Or another angle of it is that an appeal ought to have been brought before against any decision of the election petition tribunal within a specific period of time. You should bring that appeal and prosecute the appeal within a given period of time. If that appeal is not brought within that time, it's also not prosecuted within that period of time. By law, that the Constitution itself, Section 25. Or the further additional out to the Constitution, it could be said that it is statute bad. Perhaps the Supreme Court anchored on one of those grounds to say that it's statute bad, which by itself is illegal technicality, because those provisions have been important to the Constitution as to time-bound nature of election petition and appeals. So if it is brought outside of those periods, it could be said that it started bad.
Okay. Now, pharmacist Turiyareke, let's look at this whole thing politically now. Now, I remember before this time that at a point the PDP had to make allegations that INEC and that INEC was refusing them for them to get access to really go on to this server and all that. And of course, we've got the ruling of the tribunal and also the ruling of the Supreme Court now. Now, do you think that this whole process, was kind of deliberate?
in my opinion, I'm not a lawyer, but in my opinion, we have had to look at these issues from the wake of the last election, when the presidency was very reluctant to put signature to certain amendments that was made to the Electoral Act. To me, that has paved the way for the INEC, to escape their responsibility in case of any eventuality, and that is what we are seeing now. The truth of the matter is that if you look at the tribunal ruling on the issue of Saba, one of the reasons they gave was that they cannot delve into the main issues of the petition at the interlocutory stage.
At the preliminary stage. Yeah.
Okay, could we now reason that they could delve into it after that stage? After that stage, okay, I don't know. But again, the Supreme Court has gone ahead to say, you see, this whole thing was a waste of time.
Status bad.
Yes. You know, there were two applications, two different applications, and especially the one of the server, they said it was a waste of time that lacked basis. In my opinion, all of this has not gone ahead to enrich our jurisprudence in a manner that will give or place enough hope on the judiciary going forward. And it's a cause for concern, not necessarily based on which of the parties you are affiliated with or not. But again, there are substantial issues within the provisions of law that will always give an escape to those who want to take this position or that position. And that is what we have seen here. Article still has issues in the lower courts. For example, one of the 5 major issues for determination of the case includes is Buhari
over age.
Was it eligible ab initio to have contested election? One. Did he submit falsified documents to INEC?
That's his educational qualification.
Yes. Did he, then again, did he score the lawful votes required to be declared the winner of that election?
Yeah.
Did the process, was it marred by corruption and those other malpractices and all that? Then lastly, was the process, did it substantially, well, how do you put it? Did it substantially comply with the provisions of the Electoral Act? Those are the things that are there to be determined. I think we still has a very good chance, and you cannot rule out political leanings and considerations. There are certain things we cannot say here because we cannot substantially provide evidence for them. Some people are inferring that what happened in the Honore case was a look into the future. Then some persons have also said that the so-called former Chief Justice of Nigeria was also found to be hobnobbing with some members of the opposition.
I was privileged to some information.
Yes, and they could not actually say it didn't have their sympathy. You understand? All that is there. Now, what I want to say is this. It does not augur well for our country at all. Especially when we begin to understand the role that the judiciary play in a democratic setting. I tell you, this is not about APC. This is not about PDP. It is about us.
Okay. All right. Now, Barrister Emata, you are a constitutional lawyer here, and because this whole thing boils down to our constitution as a country and as a people. Now, I remember before this time, we talked about the 2019 election. Of course, we talked about the Electoral Amendment Bill. Now, if the president had accepted to that Electoral Amendment Bill, and of course the issue of electronic results now becomes a part of the Constitution, do you think we would have been here today concerning this case?
Yeah, thank you. I will make a brief clarification before I delve into your question. You know, the appeal of yesterday, or rather the judgment of the Supreme Court, was on two different appeals. There was one that had to do with the server, which was a ruling of the tribunal on the given on the 24th of June. And of course, there was an earlier appeal based on the ruling of the tribunal, you know, given on the 11th of June. So, of course, the 24th of June ruling, which was appealed, is the one that borders on the issue of the server. So let me just quickly answer your question. Of course, the signing of the electoral bill would have saved us from this drama of INEC not denying that it has a server, because of course that's provision, or rather the bill had certain provisions on this electronic transmission of results, right? And in law, we say you cannot put something upon nothing and expect it to stay there. It will surely collapse. And it's quite unfortunate that INEC is not capitalizing on the non-signing by the president or non-assenting by the president of that particular piece of legislation. And again, it's a big moral question. If INEC, because my learned colleague actually made reference to what the independent electoral state rec for Akwa Ibom said, Mike Higgin, a respected gentleman, that of course they had a server, he won't give an outline of the various processes, you know, at the level of the polling unit, how the card reader will be used by the polling agent, the polling unit officers to transmit, you know, results to the central server of INEC. And of course, money was budgeted for that purpose. You know, the reason why democracy is not working is because we hide under certain, as it were, technicalities. You know, because if we say we are reforming a system, everybody should be seen as a stakeholder. I won't blame the courts, because it is what you present before the court that the court will act on. And on the issue of the server application that the petitioners brought, I mean, for them to be given permission, right, to inspect the server. If INEC, as the second respondent, or not the first respondent, because INEC is one of the respondents, have actually gone the extra mile of saying we don't have a server, we are not in possession of a server, and parties are doing issues on that particular point, there's no way the court can grant such a permission. Because if at the interlocutory stage somebody says something does not exist, you cannot rule on it. And I think I totally agree with the Supreme Court. If they say, of course, the court had exercised its discretion both judicially and judiciously. Because granting the petitioner's access to the server is accepting the existence of that server. Which, of course, the non-signing of the electoral bill, amendment bill, has created as a lacuna in the law. So it's quite unfortunate, because we may not see that it will have a terminal effect on that petition until when, of course, the Court of Appeal has said they will give 7 different rulings on the day of the final judgment before they give that final judgment. Because first, the respondents are challenging the competence of the petition, and the issue of jurisdiction also comes up. So it's quite unfortunate that it may have some effect, which I will not want to comment since the matter is still sub judice.
All right, now talking about, because I know one is trying to exercise caution, because we still have some aspects of the whole case still in court. The issue of whether Buhari has the required qualification is still there. Then you talked about the certain amounts of votes that you are supposed to get in order for it to be declared the winner. Now, Barrister Abariwana, now let's look at the whole scenario. Now, if Atiku Abubakar has lost on this server thing, I mean, what do you think other petitions would be enough for him to maybe, come out victorious in the whole case, in the whole petitions?
It will be the by section 138 of the Electoral Act. There are several grounds, upon which a candidate can challenge an election, of any person declared to be the winner. Qualification is one of them. Securing majority of lawful vote cast is another. No compliance with the Electoral Act and all of that is another. So corrupt practices is another. So there are so many grounds upon which an election can be challenged. Exclusion of a candidate is another. So this one, for me, had to do with lawfulness, vote cast, majority of lawful vote cast. is just an aspect of it. From the way they have put together their petition, they have tried to show that by the end of the day, when the results were finally, collated, they are sent to the server. According to them, they had majority of the full vote cast.
I think what they have 16 million plus,
yes,
as against
what
14
they
million.
have, yes, what they have in the server is different from the paper or hard copy
that was read. Yeah.
So and for that reason, the court should look at both and see that they are the winner. So that was just one aspect of it. And like I said earlier, the INEC and the APC lawyers saw through all of this, and they came out with the position to make a bold faith denial that, of course, we don't have a server, because if you admit that you have a server, then the product of that server has to be examined. And when that is examined, that makes their case much easier, like a done deal. So they try to make it difficult for the petitioner by denying that they do not have a server. The evidence, overwhelming evidence coming forth with the interview of Michael Guinea, ad hoc staff of INEC that have come before the tribunal to testify as to how they transmitted results to the server. Petition by Festus Keyamo asking for certain persons to be questioned for hacking into the server of INEC. So these are all obvious facts. So they made the case more difficult for Atiku, trying to prove now outside of what the result they have at the server. So it's just one tiny aspect of their petition.
Okay.
There are several other grounds upon which the petition, still goes. So I believe that they should go to look into the other ground. For these particular grounds, for me, it will affect that ground substantially by reason of that particular aspect of INEC server. So they could use other grounds. They should look at the hard copy results. Now, they are left now to look at the hard copy results and to see what regularities they are to still challenge the petition.
Okay, Pharmacist, I also wanted to comment on this, sir.
You see, Evans, when my friend was talking, what just kept going through my mind is this. We have been able to establish that certain lacuna created by our law has given vent to some of these occurrences. Now, my mind was zeroing in on the legislature. If we, as students of democracy, we can tell that the legislative body happens to be the hub of the democratic system. Now, since that amendment was thrown out, was not signed into law by the president, you will begin to wonder
why did they veto it?
Yes, why? What is the legislator doing at a time like this? Preparing for the future. Because very soon, we have had elections in this country before where irregularities and malpractices marred it without compliance. And even the former president once said that the election that brought him to power was, not very, very credible.
Yeah, Pharmacist, but we can't really blame the legislators. Now, remember all that happened. Remember at the time, I think it was about 3 times that this same bill was sent back. It was sent back. And I think the last we heard from it was that Nigeria is a signatory to United West African something and all that. And that was...
No, you're not getting that. And now, today there's a legislative, but that was the 8th Assembly.
Yeah.
That is the 9th Assembly. This is the 9th Assembly.
Are you suggesting that
I was of the opinion
that they should go back?
No, I was of the opinion.
Introduce the bill?
Yes, it should be introduced. And people should clamor for it, because we have also come to that point where we have all agreed that the processes that lead to bringing up leaders is so flawed that we always have the wrong person sitting on the saddle. I am sorry to say this. I have had to take a close look at some of the individuals who have emerged from various platforms to represent us at the assembly. You will know that some of these people, they are not there to serve the people, to create laws that will help govern this country very well. Because if right now we are waiting, folding our hands, waiting for 2023 to sneak in on us again, and we are inside the same problem, it will be a shame. Because based on what is going on now, what the judgment of the Supreme Court and what the tribunal has said, I mean, well-meaning Nigerians, the legislators, they should begin to think, how do we now plug these holes so that we a repeat of this kind of, what do you call it, I don't know, a repeat of this kind of elementary stuff will not, happen to us again. These are the areas we should be looking at right now, because the question is that we are not genuinely in search of a democratic setting that will all give the dividends of democracy to the entire people. But what we are looking for is people who want to go into office, serve their godfathers, get a ticket to come back again and begin to recycle themselves and repeat what they are doing, to the detriment of the general populace. That's what we get. And that's where our concern should be. That's why I mentioned that this is not about Atiku, this is not about Buhari, this is about Nigeria. We should be able to look at it from that perspective. We should not sit in one place clapping, oh, this one is going to win, that one is going to win. No, that shouldn't be our concern as concerned citizens of this country. What should be our concern is how do we enrich our jurisprudence? How do we make our judiciary that hope of a common man? How do we make it an impregnable fortress that everyone can look at and say, well, we will get to judiciary, we know we'll get something there.
So use Onogen paradigm.
I know, but I didn't get
unfortunate because if you look at the Onogen paradigm, it's something that cannot fly in the face of the allegations that were brought against him. And I think he's a metaphor of the Nigerian judiciary. Recently, I presented a paper at the Uromi branch of the Nigerian Bar Association, Politics, Money, and the Future of Justice in Nigeria. It's quite unfortunate that we don't have fearless judges as we once had in the 80s, between 85 and 89, the likes of Kayode Esho, that looked the military in their faces and told them, this your decree is unconstitutional. We didn't have all these, shenanigans of, oh, the Supreme Court will look at a very beautiful petition like the one we saw in the Oshun case, or because somebody didn't sign attendance. For God's sake, are we building democracy? I'm a lawyer, but I don't think the judiciary has done enough. We don't have judicial activism again in Nigeria. We know actually the outcome of these elections. We know the winners, we know the losers. The judiciary themselves, they know.
Yeah,
but we now depend on technicalities. Would that deepen democracy?
Yeah, but we have authorities that tells us who the winners are, so it's not...
Of course, we know INEC, has INEC ever been independent? INEC that budgeted, the National Assembly voted money in the areas of hundreds of millions for a server. They came out to tell us that once this thing moves from the polling unit through the candidates, it goes to the server under their guidelines. They came up with their guidelines made pursuant to the Electoral Act. Yes. And you now turn around to say the server does not exist. The world will be laughing at us when they see all these things, that we are just deceiving ourselves. All those things INEC did was preparatory to when the president signs this bill. Of course, we now have a basis. The man now refuses to sign. And you are now trying to capitalize on that. Morally speaking, if something exists, say it exists. Yes. Allow the court to decide. Yes. But when you say it does not exist, you place the court in a catch-22 situation. Because the court cannot now say something does not exist. Yeah. It's like you say that we don't have, you now tell us we don't have ITV here. Can we come here for an interview? For this kind of program? No, we cannot come for this kind of program. Because you are not blowing hot and cold. And that's where we are. And I think the way forward, because if the National Assembly fails to start acting, we saw the incident of Nuremberg, where Ike Kurumadu was attacked. I'm not an advocate of violence, but at the same time, there's a level to which you push a man, he gets to the wall, and he will fight back. Just yesterday, video footage came of a senator that was slapped in a train. I think that should be in London. Senator Buruji Kashomo, the senator representing Ogun East senatorial district. Nigerians are now responding. People talk about revolution now not succeeding in Nigeria. Unfortunately, in Europe, our politicians, when they go there, they are now feeling the hits. It tells me one thing, that a day will come when the people will not take this again. It may not be at home where, protests are not allowed. The German government came to say, yes, these people have a right to protest. They are teaching us democracy.
But you don't try to take over the government.
No, it's not a question of taking over the government. The word revolution is not only when you take up arms. Revolution can be by way of conduct. The Arab Spring didn't come by arms. Somebody did a self-emulation. He burnt himself alive. And that sent a signal that we cannot accept this kind of situation again from government. where the government now behaves as if they are overlords. Democracy is a social contract. We are the ones that send them. We are the masters in the democracy. The people, the electorate. Because Section 14 of the Constitution says sovereignty belongs to the people of Nigeria, from whom government derives their power and authority. Okay. But unfortunately, it appears that this sovereignty is just with the National Assembly and the President. The people don't have a voice. Their votes don't count. So I think there's need for electoral reforms. And until we do that, we will keep hearing slaps and blows. You know?
All right, gentlemen, thank you so much. Now, reactions from the PDP concerning this issue is that the PDP has said that the ruling of the Supreme Court yesterday does not mean an end to its petition on the 2019 presidential election. The party asks Nigerians to be guided in their analysis and conclusions on the court's ruling. In a statement by its national spokesperson, Kola Olobodinyo, the party explained that the case that was determined by the Justice Damidio Mohammed-led 5 panel was an appeal filed by the PDP and, of course, article on a ruling of the Presidential Election Petition Tribunal concerning an application made by the All Progressives Congress to withdraw one of the replies made to the latter's complaint. So we still have other petitions concerning the 2019 election. Gentlemen, I really want to say thank you so much. Please let's take the handshake down.